When you're pulled over on suspicion of driving under the influence, one of the first tools law enforcement officers use to evaluate your condition is the standardized field sobriety test, commonly known as roadside sobriety tests. These tests give police officers an opportunity to observe your physical and mental state to determine if you appear impaired by alcohol, drugs, or both. The purpose of these tests is to help establish probable cause for a DUI arrest. However, what many people don't realize is that field sobriety tests are voluntary. You are not required by law to perform them. Refusing to cooperate with FSTs can actually be a strategic move to protect your rights and limit the evidence available for use against you in court. Let's take a closer look at the different types of sobriety tests, why they are voluntary, and how refusing them can benefit your DUI case. What are standardized field sobriety tests? The National Highway Traffic Safety Administration has outlined a series of standardized field sobriety tests designed to assess a person's coordination, balance, and cognitive ability, factors that are often impaired by alcohol or drugs. The three most commonly administered tests are horizontal gaze nystagmus. This test tracks the movement of your eyes as you follow an object from side to side. The officer checks for involuntary jerking or abnormal eye movements, nystagmus, which can be an indicator of impairment. One-leg stand. You are asked to stand on one leg while counting aloud. This test checks for balance and physical coordination, both of which can be impaired by intoxication. Walk and turn. You are instructed to take a series of heel-to-toe steps in a straight line, turn, and then walk back in the same manner. This tests your ability to follow directions and maintain balance. While these tests are designed to assess impairment, they are far from foolproof. Factors such as anxiety, fatigue, poor road conditions, and certain medical conditions can lead to inaccurate results, giving a false impression of intoxication. This is why it's important to know your rights and understand that these tests are voluntary. Field sobriety tests are voluntary. One critical fact that law enforcement officers often don't mention is that you have the right to refuse to take field sobriety tests. These tests are not mandatory, and declining to participate doesn't carry the same immediate legal consequences as refusing a chemical test such as a breathalyzer or blood test. In the moment, many people feel pressured to comply because they aren't aware that they can decline the test without legal penalty. However, the primary reason officers ask you to perform FSTs is to gather evidence against you that can be used in court to justify an arrest and build a strong case for prosecution. By refusing to take these tests, you limit the amount of subjective evidence that law enforcement can use against you in court. This is a crucial aspect of protecting your rights, especially if you believe that factors unrelated to alcohol or drugs, such as medical conditions or environmental factors, could cause you to fail the test. Why refusing field sobriety tests can help your DUI case. Refusing field sobriety tests can be a smart strategy for several reasons. Minimizes evidence against you. Field sobriety tests are highly subjective, meaning that the officer's personal interpretation of your performance plays a large role in the decision to arrest you. Refusing these tests prevents the police from collecting potentially flawed evidence that could be used against you in court. Prevents false indications of impairment. Numerous factors can interfere with FST results, such as medical conditions, nervousness, and even uneven road surfaces. For example, if you have a bad knee or poor balance, you might struggle with the one-leg stand or walk and turn tests, even if you're completely sober. Shifts focus to more reliable evidence. By refusing to perform FSTs, you force the prosecution to rely on other forms of evidence, such as chemical tests or video footage. This evidence may be less subjective and can give your defense attorney more opportunities to challenge the case. Reduces confirmation bias. Police officers, like all humans, are prone to confirmation bias, the tendency to see what they expect to see. Once an officer suspects that you are impaired, they may interpret your behavior during field sobriety tests in a way that confirms their suspicion, even if the results are inconclusive. Refusing the test limits the chances of this happening. Common types of roadside sobriety tests. While the three FASTs mentioned above are the most common, law enforcement officers may also use other roadside tests to assess potential impairment. These can include lack of conversion, a test that measures your ability to perform dual tasks, such as counting backward or reciting part of the alphabet. Finger-to-nose test. You are asked to close your eyes, extend your arms, and touch your nose with one finger. This is meant to assess coordination. Romberg test. You are asked to tilt your head back, close your eyes, and estimate the passage of 30 seconds. This tests your balance and ability to gauge time, which can be affected by depressants. Each of these tests comes with its own set of variables that can lead to inaccurate results due to physical limitations, fatigue, or anxiety. Therefore, refusing these tests can prevent unnecessary evidence from being used against you in court. How refusing FSTs can strengthen your DUI defense. Refusing to participate in field sobriety tests is a lawful exercise of your rights and can have several positive implications for your DUI defense. An experienced DUI attorney can challenge the validity and admissibility of other evidence, such as the preliminary brake test or the officer's observations. By doing so, they can weaken the prosecution's case and potentially reduce the charges or have the case dismissed altogether. In some cases, your attorney may argue that your refusal to take FSTs was not an admission of guilt, but a reasonable action to avoid providing flawed evidence. With the right lawyer by your side, the decision to refuse these tests can lead to a more favorable outcome, such as reduced penalties or even acquittal. Are chemical tests voluntary too? While field sobriety tests are voluntary, chemical tests such as breathalyzer or blood tests are a different story. In many states, including Colorado, drivers give express consent to chemical testing simply by operating a vehicle. This means that refusing a chemical test can result in consequences such as license suspension and penalties in court. However, even though chemical test refusals come with consequences, they can still be challenged in court with the help of a skilled attorney. It's essential to understand the laws in your state and consult with legal counsel to protect your rights. The role of a DUI lawyer: protecting your rights. Navigating a DUI case without legal assistance is a daunting task. A qualified DUI lawyer can review the evidence, challenge the procedures used by law enforcement, and argue on your behalf to minimize or dismiss charges. They can also highlight the subjectivity of field sobriety tests and argue that your refusal was a lawful decision rather than an indicator of guilt. By understanding the strengths and weaknesses of the evidence, your lawyer can develop a defense strategy that gives you the best chance of a favorable outcome. They can challenge flawed FSC results, question the reliability of officer observations, and negotiate with prosecutors for reduced charges. Protect yourself by knowing your rights. Field sobriety tests may seem like a standard part of a DUI stop, but they are completely voluntary. Refusing to participate can protect you from incriminating yourself based on subjective and potentially flawed evidence. By knowing your rights, refusing FSTs, and working with a skilled DUI lawyer, you can build a strong defense and improve your chances of a positive outcome. Remember, every DUI case is different, and the best defense strategy will depend on the specifics of your situation. If you're facing a DUI charge, consult with a qualified attorney who can guide you through the legal process and ensure that your rights are protected. Thanks for sticking with me to the end. If you found this video helpful and want to stay informed about your rights, DUI defense strategies, and more legal insights, don't forget to hit that like button and subscribe to the channel. Make sure to turn on the notification bell so you never miss an update. Your support helps us bring you more valuable content. Thank you for watching and see you in the next one.